live. So, disclosure of agency. I told you that there's, yesterday I said 80 questions general real estate, 30 questions state. So that means 110 questions in total on the exam. If we divide 110 questions by 22 chapters, we're looking at 5 questions per chapter. What I want to point out, as I said earlier and yesterday, chapter 1, 2, and 3 are the most heavily tested. In fact, this section alone starts here in this page, ends on page 36. This section alone has 5 to 6 questions. So I told you 5 questions per chapter. This section has 5 questions, okay? So pay close attention and ask questions because it does get complicated. So disclosure of agency. What is agency again? Employer-employee relationship, right? Yes, that's perfect. So you guys are absolutely right. So somebody hired you and created an agency agreement where you represent them, right? And they're represented by you. So disclosure of agency, it says New Jersey regulations require licensees to present a consumer information statement, or CIS. And this is a form of disclosure to all sellers, buyers, landlords, and tenants on the sale or rental of all 1 to 4 family residences and vacant 1 family lots. Now, 5 units or more, right, are not residential. They fall into the commercial. So, it says here, although consumer information statement or CIS is not, please circle, is not required for other transactions, commercial buildings, or multi-unit apartments, for example, written disclosure of agency can be a prudent precaution for the broker in all situations. What does that mean? Even though it's not required, you should still disclose agency relationships. Now, next paragraph, I want you to highlight, underline, put stars, arrows, bubbles, whatever you have to put. But you got to remember what's here. The CIS, Consumer Information Statement, describes the types of business relationships that we can enter into with a customer or client and the duties associated with these relationships. So, CIS, underline, Consumer Information Statement, underline and circle types of business relationships, because that's what it says. The CIS describes the types of business relationships. Now, what kind of business relationships can we enter into? It says right here, a real estate agent can function as a sales agent, buyer's agent, look, it's in bold, disclosed dual agent, or transaction broker. So we can represent the seller, we can represent the buyer, we can represent both, or represent none as a transaction broker. There's another one here. Don't worry too much about that one. You need to know these 4: seller, buyer, both, or none. These are the 4 you need to remember. I want you to go to page 36, and then we're going to come back to page 34 and 35 in a second. On page 36, it says, furnishing the consumer information statement. What does it mean to furnish something? To provide or produce, right? So where it says furnishing, I want you to write providing. Providing consumer information statement. Okay. Now, when must we provide the consumer information statement? It says right here, real estate agents are required to furnish a CIS, please highlight, underline, put stars, before any discussion of a seller, landlord's, buyer's, tenant's motivation or financial situation is initiated. So the moment somebody says, hey, Bruno, I want to buy, whoop, wait right there. I have to disclose something to you. Bruno, I want to sell, whoop, wait right there. I must disclose something to you. So before any discussion about potential buying or selling, you have to disclose the CIS. Okay? Now, if the first discussion takes place by telephone or in a social setting, the seller or buyer must still be verbally informed about the possible agency relationships and alerted to their implications. So, if it's by phone or in person, but in a social setting, like we're not sitting down to do business, right? We're at a cafe and, hey, you want to sell or you want to buy, we must still disclose what you can expect of me. Because that's what the business relationships are. And let me show it to you. We'll come back here in a second. Go to page 34 and page 35. Your book does not have this, but I want you to write to the top of both pages. Big, bold letters. Please read me. Both pages, you're going to write, please read me. Got it? Oh, yeah, that's what it was. I thought it was a blinker. She's like this, and I'm like, okay. I saw something. I'm like, what is that?
Question.
Traditionally, people go like,
I know. How often, for instance, you're dealing with
go.
You're dealing with a seller,
Mm-hmm.
but then they want to buy something,
Okay.
right?
Okay.
So you have them fill this out.
Okay.
Let's just say you sell their house, they don't find anything they like, they go into like a rental space. You're still communicating with them.
Mm-hmm.
Does that mean that they need to fill this out again?
This is filled out for every relationship.
So if they're
Let me explain what this is first, and then I'll address your question. For one reason.
Yeah.
People must be well informed about potential agency relationships. So it says right here, this is the CIS, must be disclosed. So everybody must get this at the time that they're buying, selling, or renting. Okay? So this is a quick summary you can give over the phone, and then once you sit down with them, you give the rest. But as a seller's agent or sub-agent, I, as a licensee, represent the seller, and all material information supplied to me by the buyer will be told to the seller. So, Mr. Seller, I represent you. If the buyer tells me anything that would affect your position, I will transmit to you. I don't have to tell anything to the buyer, but my obligation is to you, the seller. If I represent the buyer, then it's the same thing. Whatever the seller tells me, Mr. Buyer or Mrs. Buyer, I represent you. So anything that's told to me, I will give to you. Does that make sense? As a disclosed dual agent, guys, I represent both. So it says here, I may not, without express permission, disclose the seller will accept less than the listing price or that the buyer will pay more than the offered price. Meaning, I'm here to conduct a transaction. I'll represent you both to the best of my ability. I will keep confidential whatever your situations are. And Mr. Seller, I cannot tell you if the buyer has more money. And Mr. Buyer, I cannot tell you if the seller will accept less. All right? Or 4, as a transaction broker, I, as the licensee, do not represent the seller, do not represent the buyer, and all information I acquire from one party may be told to the other party. So now if you tell me going through a divorce, I might tell the buyer. If the buyer has a whole lot of money, Mr. Seller, they have more money. Does that make sense? As a transaction broker, I don't have any obligation to either one. I'm managing the transaction. Now, this is just a quick summary. You guys need to read this. Now it goes in detail. Seller's agent works only for the seller and talks about the obligations they have. On the right-hand side, buyer's agent works only for the buyer and tells exactly what they can expect from you. Disclosal agent, again, goes in detail. Transaction broker, next page. He goes in detail. So, sorry, just one second. So you guys have to read this because the CIS must be presented, furnished, provided at the beginning of every relationship. Okay? In fact, they must sign that they received. Sellers, buyers, and then we tell them how we expect to represent them. Okay? This is not a contractual agreement. This is just a disclosure. It's a notice to the world of how you could represent these people. Does that make sense?
Mm-hmm.
Sorry.
So, can you give me an example of the transaction broker when you define yourself as a transaction broker?
No, you choose. Like, Olga, you want to sell? I don't want to be a seller's agent. I'm going to operate as a transaction broker. What does that mean? I'll do anything in my power to get the transaction to go through. Legally, of course. But I am not liable for certain representations on your side. So if you tell me that you really, really need to move out, I might tell the buyer that you're very motivated. And that might relate to the buyer that low offers are acceptable. I won't tell him to lowball, but I might say that you're motivated. That usually, again, triggers low offer, or any offer is considered. Does that make sense?
Yeah, but do you still, like, let's say, okay, so do you still help them find a buyer or find a seller?
We do everything. It's just, it limits liability.
Okay.
So as a transaction broker, like, I can never say that you're my client, because you're not. You're a customer. All right? So my first interest is getting the transaction done. See, if you're my client, you're up here, then me, then everybody else. If I'm a transaction broker, then I'm here, the transaction is here, and then everybody else, the seller and the buyer. You guys got it? So as a client, I'll bring you all the way up, you're first, before anybody else, including myself. Transaction broker, the deal is what matters to me. So, Mr. and Mrs. Seller, we can limit my ability to do my business by protecting your best interest, even if you will cause the deal not to go through. Because sometimes certain information might be needed to get the deal to go through, right? Or you let me do what I need to do as a transaction broker. Now, the reason why we have to disclose this, and you guys will have to read page 3. In fact, page 34, page 35, fold the tops. The corners, just fold them. Because this will be part of your real estate career. Every single client must have that top folded, okay? Those 2 pages must be disclosed. Now, what was I saying? You have to sit down with them and say, hey, listen, as a sales agent, I represent you, and I'll do the best for you. As a transaction broker, I don't represent you, I'll represent the transaction. And the reason why we give this is because the seller is entitled to say, oh, wait a minute, Bruno, if you're not going to represent me, then we're not doing this. I want somebody else. And I, as the agent, can say, well, here's the thing. I really don't want to operate as a sales agent, so I appreciate your time, and I move out. Does that make sense? We are in no obligation to be a seller's agent or a buyer's agent. No obligation. We can choose how we operate. In fact, most brokerages right now choose to be transaction brokers. Right? Only if the seller specifically or the buyer specifically states, you're going to represent me and me alone, is when we consider changing that. Now, every brokerage has their own rules, so don't quote me on this. But I'm saying we have to give you, this is by law, we have to give the seller or the buyer the opportunity to say no. Just like disclosing, representing both sides. I represent the seller and represent the buyer. The seller is entitled to say, oh, wait a minute, you're either going to represent me or represent them. Never both. You guys understand? That's why this must be presented before anything else. Mr. Buyer, I might have a listing that matches your needs. If that's the case, I will represent you and them. Are you okay with that? They say no, then you know what? I'll find you another house. Even though that one was the house for them, they want to feel protected. They want to feel that I represent them, not both sides, and getting full commission. So clients are entitled to always, always, always reject agency agreements. Yes?
Can you ever switch sides?
Well, if you're the listing agent, you can switch sides. If you're the buying agent, you can't switch sides.
Okay.
It's you represent who you represent. Can you represent both? If they allow it, yes. Can you say, well, since you don't want it, I'm going to go to next door? No.
So you can start out as one
I'm
and then
saying,
become like a dual because so
Well-
you have a seller.
That's what it says here.
Yeah.
See, it says right here, look. Declaration of business relationship. I, Bruno, as an authorized representative of New Direction Realty, intended as of this time, to work with you as sales agent only, buyer's agent only, seller's agent, and disclosed dual agent if the opportunity arises. So that answers you. Buyer's agent and dual agent if the opportunity arises.
Right.
But they're entitled to reject these. Transaction broker only, or then this is for if we have multiple properties. So the problem with this form is that most agents provide this after everything. That's illegal. There's some brokerages out there that tell you, hey, look, there's a date here. You see the date? Have them fill out everything. Do not date it to the date that you filled it out. Backdate it to the day you first met it. That is illegal. This is the first document that they must be aware of. It's not when you put an offer and have them sign this. It's not when, and this is the most ridiculous one, but I had a gentleman here, he was a retired cop. It says when he closed on his property is when he found out about this. After closing, so we're talking about 3 or 4 months later, is he found out that he had options. Are you guys understand this?
another question. Hypothetically, if I'm on the phone with you and I'm acting as your agent, can I record me saying, hey, this is what it is, this is what it's not?
So that's a very good question, but recording is not enough.
Okay.
The statement should be then furnished at the next meeting. So even though you're saying over the phone, the statement should be then furnished or provided in the next meeting or included in the first fax, mailed, or delivered material. If no discussion of motivation or financial situation has taken place, the agent must provide the CIS before any property, listed or unlisted, is shown. In fact, look what it says here at the bottom. Sellers and buyers must acknowledge receipt of the CIS on all offers, contracts, and leases. So you can record all you want, still not valid, until they sign the document.
Hypothetically, if it's a court situation and the buyer and or seller is going to court because, you know, they're just unhappy, and I furnish the recording saying, hey, you know, I did give you notice.
Recordings are not authorized in court unless, well, we're going to get into the legal side of it. Right now it's not.
Okay.
Okay, but recordings might not be authorized in court. Let me correct that.
Unless they know that they're being recorded.
It depends. Certain states you don't have to.
Right.
Yes. So,
Right. You give this form out, right?
mhm.
And they're like, yes, seller's agent only.
Okay.
Right? Is that like normal? Is that like the you would say?
Lately, the normal is transaction broker.
Okay. Okay. But let's just say seller's agent only. Then you furnish a buyer. Can they re-sign this?
That
If they're
that
not
is not a contract, that's a disclosure only. So at the time that we put a contract together, an offer, there's an additional document that restates everything we just said. And it says, now
So
I represent you
Yeah.
as this or that. So if you guys read what it says on page 35, right at the bottom, what it says is, as of now, I intend to work with you, right? Let me go up.
Mhm.
So as of now, this is how I intend to work with you. As of this time, right here. Could it change? Yes, it says as of this time. This is what I intend. You got it? Could it change? The answer is yes. So if you put as a sellers only or buyers only, and they're okay with it, we can change at that point to be disclosed dual agency. Can we switch sides? No. Can we work with both, even though we said we're just going to work with one? Yeah, if they allow it. Okay, and that's what we're going to go over in a second, actually. What do I have? Okay, so I cover this, cover this, cover this. Right here. Termination of agency. It says the agency relationship may be terminated by any of the following. Death or incompetency of either party, destruction or condemnation of the property, expiration of the term of agency, mutual agreement to terminate agency, renunciation by the agent, revocation by the principal, bankruptcy of either party, or completion or fulfillment of the purpose for which the agency was created. So for any of these reasons, agency could be terminated. What is agency again? Employer-employee relationship. So if you hired me, right, we created an agency. Seller hired me. I'm the agent, right? He could be terminated if the seller dies, because I never die. So if the seller dies or becomes incompetent, right, then it ends our relationship. The property got destroyed or is condemned, or we'll talk about it later, eminent domain. The agreement expired, because we had a 6-month agreement, it expired, so no longer valid. Now, hopefully, the reason why the agency terminated is the last bullet point, which says completion or fulfillment of the purpose for which the agency was created. What does that mean? We closed. We made money. You got it? We helped the seller sell, we helped the buyer buy, and we're happy because they're happy. Right? Say yes?
Yes.
Good. Participation at last. All right, where it says buyer as principal, we already covered this. Just highlight the last sentence. It says if a broker represents both parties in the same real estate transaction, he or she can collect only from only one of them. So even though you represent the buyer, even though you represent the seller, you're representing both. You only collect commission from one. Now, it's full commission. It's just that either one party or the other pays. There's no splitting, 3%, 3%. You got it? You still get the full commission, but it's one side or the other paying the commission. Dual agency. So this addresses your question from yesterday. Dual agency means that the broker represents both parties in the same transaction at the same time. While dual agency in itself is not illegal, undisclosed dual agency is. Highlight, underline with stars. Undisclosed means we did not tell the buyer we represent the seller. We did not tell the seller we represent the buyer. That is illegal. Okay? Ellie, you had a question?
As far as collecting commission from...
By the way, I shouldn't be addressing your questions. You don't have your name tag. Rule number 1, name tag.
Can we choose who we ask to pay commission, or do we just get commission from whoever agrees to pay?
Whoever agrees to pay. Okay? So traditionally, the seller is the one, we talked about this earlier, traditionally the seller is the one that pays. Okay? There's more. I mean, they're disposable. Don't worry about it. Just throw it out. But you guys will learn real quick is that I capture names and get all your information real quick. The name is not for me. It's amongst you guys. I've had classes of 50 people, not here, but previous school, 50 people, and I got all their names in the first day. So that I don't have a problem. Net break. Well, Lucille came from one of my one-day classes, right? I was there for one day. Like, hey,
I'm surprised you remember my name yesterday.
see? And how long ago was that?
It's almost 2 years ago.
Almost 3 years. I'm dangerous, I'm telling you. Don't give me your social security number. All my business partners, one of the things they do is give me their passwords, their socials, their date of births, because they might not remember it. So,
This is the reason you are there, here.
that's right. Well, at least know that I will not do any harm with it. I think. All right, conflict of interest on the right-hand side. It is a trick that you guys should learn, how to get people's info. Not like social security and all that stuff, but people's name and remember, especially remember details about them. It's very, very important. Now, if you guys notice, I'm always touching a few things as I go on each person, right? So as long as you tell me, from there on, I'm going to repeat a bunch of times. That's one of the tricks that I use to always keep your name and remember something about you, all right? So find a way. Use that because it is very valuable when 2 years later, you see somebody and you're like, hey, how are you? It's been a while, right? And you remember exactly where that person came from. Does that make sense? It makes a huge difference. I have people that I haven't seen in probably like 3 or 4 years call me up and say, hey, do you remember me? I'm like, of course, you're my student on my Saturday class back in 2016. Yeah, that bad. I'm sorry? I what?
You're Santa.
I told you, I checked the list twice. Every year.
So you just do that by repeating what people say, and that's how you remember it.
That's one of the things. But then I do a lot of role play. As if you guys notice, I involve everybody one way or another, even if you don't want to.
Why are you looking at me?
It's like, why is he using it?
How he remembers.
That's all I remember, yeah. So that's it. And I use it. It was difficult in the beginning, getting people's, I'm good with faces, right? But getting people's names it was difficult for me. Now, because of the tricks that I use, one of them is this, getting people involved, creating scenarios, picking people out of the crowd, makes it a lot easier to remember. Okay? So just find a way to do it. Conflict of interest. So conflict of interest may occur when the agent is called to a listing interview and finds a seller ready to let the property go at a ridiculously low price. Now, the courts have held that even though the property is not yet listed, the seller is relying on the broker's expertise and may become a principal. Now, the licensee who decides to buy the property immediately without notifying the seller of the true value is operating under a conflict between his or her own interest and that of the seller. So here's what we're saying. If you guys are good realtors, one of the things you're going to do is, hey, see me, I'm going to go to your house to list your house. You called me up, Bruno, want to list my property, right? And before I get there to your house, I already have a full description of your property to the best of my knowledge, right? Public records, right? And I already have comps. I have comparables, evaluations of what the market is doing in your area, the schools, the crime, all demographics of your property. Do you understand? So when I get there, I'm ready. I'm ready to prove to you that I'm above average. I'm not like the other realtors. I'm the one you have to choose. It's not the one you need to, have to. It's not the one you want to, have to. I'm the only one that will list your property for this rightful price and make it happen. Does that make sense? So that's what I'm going to do. I'm going to be ready for it. Now, when I get there, one of the first questions I ask, even though I have the report, right? Let's say this is the report. This is your property right here. It's not. Don't worry.
You have it, it's on scene.
So here's what happens. I get there, and I ask you, Simi, if you don't mind me asking, what is the reason you're selling the house? I need to fully understand why you're selling so I know how I can market your property. Because there's a couple of things we can do. If you have time, there's no urgency. In the next 6 months, we're going to do this, this, and that. It's the laid back listing. If you have some type of urgency, in the next 3 to 4 months, I can get your house sold. If you need to move tomorrow, I can still get your house sold. And I guarantee it. The thing is, prices will change, right? The value of the house will change based on your needs. The features of the house will make a different value. Does that make sense so far? So I asked you, see me, why you're selling? And you tell me why. Great. Now, realistically, how much do you expect? And I always put realistically. How much do you expect for your property? And Simi goes like $100,000. All right? Don't get offended that I'm trying to sell your house for $100,000. But $100,000. In my hand, before I walked in, it was already in my hand, a comparable, a report that says your house is worth $400,000. What would you do, guys, if you go to a listing with a house that's worth $400 and the seller says, I want $100? Right? You're going to hide this and say, Simi, I am your buyer. Does that make sense? Is that what you're going to do? As an investor, that's what I would do. But as a realtor, it says right here, if you're not immediately notifying them of the true value of the property, you're operating in a conflict of interest. See, I'm not hired by Simi. She did not pay me yet. She did not sign any documents yet. So I have no liability to her, right? Wrong. The moment I gave you my card, I told you that because I have a license, I have liability. She was expecting me to be the professional. She was expecting me to advise her on what to do. Even though we didn't create the agency agreement yet, that license right there is what changes everything. You guys understand? Now, if after I'm telling you, Simi, your house is worth $400, why would you sell for $100? And she goes like, Bruno, I just want to leave. I'm done with Jersey. I'll leave tomorrow if I can. Well, now that I gave her the true value of her house, Simi, I'll buy your house. Does that make sense? You guys cannot jump at the purchase without telling her the true value. You will get sued, you will lose your license, and potential jail time. You guys, because that's defrauding somebody. Does that make sense? Now you have to understand, some people are completely unrealistic on their prices. They bought the house 20 years ago, 30 years ago, when it was worth $70,000, $80,000, as an example. Today, they just, especially when you're dealing, not you, Simi, but when you're dealing with elderly people, you got to be very, very careful on these things. They bought their house. It was their family house, generation to generation. They just want some money and get out of Jersey. Go retire somewhere else. Some realtors attack seniors, meaning that's their main market because of these things.
I have a question.
Yes.
So how do you have proof that you told her?
Oh, that becomes part of the contract.
Okay.
So,
that's- you
Simi,
have to know
please
the-
sign here. Initial each page of this report that I prepared. It becomes part of the contract. And I will put on the notes of the contract, per addendum, comparables, I have explained to seller the true value of the property. Simple. Seller signs, buyer signs. And because I'm an agent, part of the commission is used for the down payment. Or all of the commission is used for the down payment. So I bought your house at a very special discount, right? And no money down. My commission was used as a down payment. Not a bad deal, right? Good stuff?
Mhm.
All right, just remember, if you want to get into these type of deals, gotta tell them the true value. Either that or don't get your license. One or the other. So for 15 years, I've been doing real estate investing, but only a few years ago, I decided to become a realtor because I was afraid of these situations. When I took this course in 2005, I did not become an agent back then. I took the course, and as soon as it got to stuff like this, I'm like, wait a minute. This is going to be a conflict between what I want to do as an investor and what they're telling me to do as a licensee. So I didn't do it. So it was a big mistake because, see, you can be in both worlds as an investor and as a realtor, right, as a salesperson, and still benefit. You just need additional disclosures. But it cost me a lot more because I was relying on realtors to give me the info. Stuff that you only get on the MLS, private info. Does that make sense? Now that I'm a realtor, I see everything that's happening behind the scenes. All right? You just got to know what to do, when to jump at a deal, or when to tell them, hey, you should sell your house for more. Yes?
I've also noticed that when someone with a license is selling their own property, they have to disclose
Yes.
that they are a real estate salesperson.
Yes, you know why? Because you have more knowledge than the rest of the world. So even though it's your property, you could be using your influence in the professional side, right, to sell the property. So there's a conflict of interest, the professional and the personal side. Okay? All right, so disclosure issues, material information. So I think we already mentioned this several times. We're going to highlight most of this, which is in New Jersey, real estate brokers and salespeople are responsible for disclosing to the buyer, please underline, any defects of material nature that affect the physical condition of the property. Meaning, there's a leak, there's mold, anything that could affect the conditions of the property or value of the property must be disclosed, okay? Go to page 39. And we already, yes.
Okay, I have a question. Let's say if you're entering a rental agreement and your rental agreement, inside the unit there was like mold and, a whole bunch of other hazardous things. As a renter, can you go after the person?
So that's chapter 12. It's specifically for rentals. If the property is in hazardous condition, not habitable, right, then you can sue the landlord, yes. You can even walk away from the property without obligation to the landlord. Yeah. Okay? So, right here, we already talked about this, but it's just reinforcing it. Licensees must disclose defects that are uncoverable by a reasonable inspection. What is a reasonable inspection? For us guys, it's visual. Whatever we see is a reasonable inspection. We are not required to get on top of the stable, to lift the drop ceiling and look at it. That's not our job, that's the home inspector's job. Does that make sense? All we need to know is what we can see. And what we can't see, we must ask the seller. So, sellers should be aware, however, that courts have ruled that they are responsible for revealing any hidden or latent defects to their real estate agents. So, Mr. and Mrs. Seller, please tell me if there's anything other than what I see. Are there any leaks? Is there any damage to the structure? Is there anything that I don't see? Does that make sense? Because if you don't tell me, you might be liable. You got it? I'll be liable, you'll be liable. So every time you see latent defects means hidden defects. Something that we will find out later on. Now, has anybody ever bought a car before? Did you get a report with a car?
Yeah.
What is it called?
That's a great question.
That's a great question. I don't think that's the answer.
No. It's the
Like the Carfax?
yeah,
Carfax.
Yeah,
Yeah.
there you go.
Did you guys know there's one for the house?
Yeah.
Do you know what it's called? Do you have any clue?
Well,
Cool. An excellent source of information about past problems in any given property or building is the Comprehensive Loss Underwriting Exchange, or CLUE report. So if you have no clue what it's called, CLUE report. And it will list insurance claims for the past 5 years. Now, why do I highlight this and why do I stop here? Because in the exam, there's going to be 2 answers. There's always, out of 4, there's 2 that don't matter and 2 that are very similar. Okay? In the exam, one of the answers says, comprehensive loss insurance exchange. Now, if they're asking you about insurance problems, right, insurance claims, if that's what they ask you, then you're going to assume that the correct answer is comprehensive loss insurance exchange. But no, it's CLUE, not CLE. Why CLUE? Because underwriting is risk assessment. Underwriting is looking at the property or at the person and determining if they're insurable or not. Just like underwriting for loans is if we can lend to this person, will this person pay or not? Does that make sense? So, CLUE, comprehensive loss underwriting exchange. Okay? You guys good with that one? You have no clue, do you?
We do have to.
All right, next. New Jersey Administrative Code says that social conditions and psychological impairments are not considered physical conditions. So what we are required to disclose is, hey, there's mold. We are not required to disclose, hey, this person is mentally disturbed. Because psychological things are not physical things. All right? For instance, noisy dogs or unpleasant neighbors do not affect the property's physical condition. It affects the community, or you're wanting to be in the community, but not the property itself. And what I'm selling to you is the house, not the neighborhood. You guys understand? So, another thing that says here is suicide or other unpleasant events associated with the property are also non-physical conditions.
So if it's haunted.
Is it haunted? Can you prove that it's haunted? And even if it is, see, some people will be like, oh, somebody died here? No, I'm not buying this. Other people are like, you know what, it's still a house, no matter what. 4 walls, we're good. Other people are like, hey, great, poltergeists. Let's turn this into a TV show. Spend 4 hours looking and filming for little lights to go through. Ghost hunters. So everybody has a different perception, right, of these conditions. But everybody's affected in the same way if there's mold. Everybody's affected in the same way if there's a leak. Everybody's affected in the same way. Does that make sense? Anything that's physical conditions affects everybody in the same way. Psychological, some don't care, some will care, some get excited, some don't. You got it? Questions? I was laughing.
She's like, no to the ghosts. Yeah, I mean, they're cool. They're cool, I guess.
See, they're cool. That's it. If they can do your laundry, even better. That's what I would say. You know, like while I'm sleeping, you want to haunt me, no problem. That sheet that you're wearing, just iron it after. That's what I would say. All right. You guys afraid of ghosts? Anybody? You are. Have you seen one?
Yes,
You have?
yes.
And what did he tell you?
And tell me everything. I almost got killed. Not gonna get into it.
Okay. Did you?
I didn't understand the question.
If you're afraid of ghosts,
Oh, yes, I am.
why?
I don't know. I don't like.
I love them. I play with them. I used to when I was a little kid. I used to have a lot of fun.
Can see them.
Yeah, kids see them. Anyway.
This is the reason. I can see it.
Anyway. Then again, kids are crazy. All right, so if asked, agents must pass along any information they possess, but they are not required to investigate social or psychological conditions. So if somebody says, if somebody says, hey, but I heard somebody died here, I'm like, I don't know, maybe. You're not required to investigate this stuff. You guys got it? So, before the agent decides to pass along any kind of information, however, he or she should carefully consider how the communication might impact his or her fiduciary duties. Because if you represent the seller and you tell him to buy, yeah, it's haunted, right? You're affecting the seller's ability to sell. Because again, some people, even though that's the house, the moment they find out that it's haunted, which is not proven scientifically, not everything is, but it's not proven scientifically, so does that affect the house?
I have a question. What if there's, like, someone buried in the property?
Guaranteed, there's somebody buried in every single property.
Right.
We've
but-
been on this earth for millions of years. There's been billions of people, so guaranteed there's always somebody right underneath us.
Well, I get that.
Okay. Boom.
We all
That's all right.
have fossils, yes. But I'm saying, like, if there is someone, you know, they use their property to bury family members or whatever, do we have to disclose that?
Is that a physical condition of the property?
It's buried in the property. There's two of them in the property.
Doesn't make it, the ground.
The house is on top.
No, I'm not saying necessarily just on top.
I
I'm
know.
saying like
I
in
know
the
what you're saying.
backyard.
Is there an oil tank?
Jesus, if the oil tank matters more, I know.
Because it will leak.
Contaminates.
It will contaminate. Sorry, you're saying what?
Doesn't it make it shallow? Like if you want to build on top of it to expand the property for
Shallow?
later?
Well, once you go build, there's going to be a builder. That builder will investigate the property and the conditions of the property. So whatever you're building on top, you have to put a foundation. So if you're expanding the house, you have to dig. Once you dig, your dog will tell you. Now, offsite conditions. I'm joking. Don't know, nobody get offended by anything that I say. It's all jokes. All right? Because certain things, yes, I respect all life forms. Okay? Living or not, I respect them. But to make light of the situation and make the class, more enjoyable, I joke around a lot. So offsite conditions. What about something that's not on your property? Should we disclose, hey, the neighbor's property has this, or half mile up, there's a hazardous waste dumping site?
Yes.
Should we?
Yes.
Why?
Because it could spill over to your property.
But in 1995, several families sued the developer and broker because of that. The trial court ruled in favor of the broker and the developer. They said that there's no duty to disclose to a potential purchaser the condition of someone else's property. So you're telling me that it could affect your property, but they're saying, the court said no. Now, just like you said, people did not agree, so they appealed that decision. And that appeal made the decision reversed. So, New Jersey Supreme Court ultimately held that conditions beyond the limits of your property may be considered material facts that must be disclosed to prospective purchasers. So absolutely. Hazardous waste dumping site? How about a gas station at the corner? How about a train station that's moving closer? Sometimes they change the tracks to a different direction because it will be better. If it's moving closer to you, there's pollution. It could affect your property. Does that make sense? Mm-hmm. So yeah, absolutely. Off-site conditions, so outside of your property, could affect your property, must be disclosed. As a result of this decision, 2 disclosures for off-site conditions are now included in all contracts. One refers to new constructions, the other one to resales of existing properties. The new construction notice includes a 5-day period in which the purchaser may cancel the contract. The resale notice does not include a similar right. So if it's a brand new construction and they found out that there's issues beyond their property that could affect their property, they have 5 days to cancel the contract. All right? If it's a resale of a property, meaning somebody lives there already and selling the property, then you don't have the 5-day period. Okay?
So who provides that information? I mean, it says it's on the contract, but who's going to research?
Well, certain things we are required to research for them. Certain things.
Us as a salespeople.
Certain things, not all of it,
Right.
but yeah. If you know that there's something that could potentially affect, you should disclose. Right? Like we're going to talk about this in chapter 9. If there's a change in zoning, if there's developments that are going to happen in the area, we should know the future. What's going to happen in the town. So in chapter 9, I'll explain how to know the future.
Good question. So in case they cancel the contract, commissions and everything has to be.
Yeah.
Okay.
What about in cases of, like trees on the property, even though it's on the outskirts or whatever? Example, willow trees, they sometimes interfere in the plumbing. Do you
Okay.
have to disclose stuff like that?
So that will be the inspection. The inspector will tell you if that will potentially affect or not. Is it that close to your property that will affect your plumbing? Because remember, you have plumbing in your property connected to the main junction. So a willow tree that's 3 houses down is not going to affect your plumbing directly. It's going to affect the town's. Does that make sense? So unless it's right next to your property, and it could potentially get to the main sewer line, I don't see how it would affect you. Megan's Law. Has anybody ever heard of Megan's Law? Ella, you were asking before, right? So you know. Sex offenders, right? So here's the thing. Megan's Law requires that a community be alerted to the presence of convicted sex offenders. Everybody must know about these people. Now, it says right here at the bottom that in New Jersey, all contracts and leases on residential real estate that are prepared by licensee must include a Megan's Law statement. So every contract must include, hey, buyer, beware, you should know about sex offenders in the area. Now, it also says licensees are not permitted, make sure you underline, double underline, triple underline, not permitted to inquire about or give any information regarding the presence of convicted sex offenders in the neighborhood. So, it's a don't ask, don't tell policy. We're not going to search for sex offenders in the area and tell the buyer, hey, Mr. Buyer, just so you know, there's a sex offender next door. We cannot do that. Okay? Why? Because it's not the seller's fault that there's sex offenders in the area. Does that make sense? If we disclose stuff like that, we're affecting the seller's position to sell. It says that a buyer's broker can suggest to a concerned client that they check the New Jersey State Police website for a registry of sex offenders. So if somebody asks, hey, do you know of sex offenders? You can go on this list, check it out, and that's as much as I can tell you. You guys understand?
Some places also send you a notice when someone moves.
That's the neighborhood watch.
Yeah, they
Yeah,
send a notice.
but when you're buying it,
Right. Yeah, you don't.
you're not part of the neighborhood yet,
Right,
so you don't get that notice.
right.
Once you buy it, oh, by the way, you're a tenant. No, I'm just kidding. But we can't. It's scary, again, making things funny out of it, but until I took this class, it's funny. Like, I got kids, and, you know, sexual abuse is very common, especially nowadays. But I never, every time I moved, I never thought, hey, registry of sex offenders. So there's a lot of people that when they take this class and they get to this point, they get offended. Why don't we disclose? And my question is, when was the last time you asked? When was the last time you researched? Most people don't. We are concerned about it, and of course I want to protect my kids. I'm concerned about it, but until I took the class, I'm like, wow, I never asked. Nobody told me, but I never asked. So was I really concerned about it? No. Do you see what I'm saying? So now there's an alert. But you cannot research these things. Tell the buyer, if they're really concerned, state police website. You got it? Next, misrepresentation. Licensees must be careful about the statements that they or their staff members make about a parcel of real estate. Extravagant statements of opinion, like this house has the most gorgeous view in the world, are permissible as long as they're offered as opinions and without any intention to deceive. Making such statements when selling real estate is called puffing or enhancing the value of something. Okay? And that's okay. Statements of fact, however, must be accurate and questions answered honestly. The broker must be alert to ensure that none of his or her statements can in any way be interpreted as involving fraud, which encompasses all deceitful or dishonest practices intended to harm or take advantage of another person. So you got to protect yourself. Make sure you're not part of the fraud. So, misrepresentation at the bottom covers more than the deliberate lie intended to mislead someone, which is called fraudulent or intentional. So a lie is on purpose, right? Fraudulent or intentional. But there's two other classifications. We have negligent or unintentional misrepresentation, and these are false statements by someone who should have known better. And then we have innocent or honest misrepresentation. Like there's no way that I would have known that there was a problem here. Does that make sense? So, for example, and we're going to highlight in a second, but I'm going to cover everything with one example. Okay, well, three versions of the example. We walk into this office and we're trying to list this office for rent. One of the first things we must do, realtors, is look around and inspect the property. If there's any apparent damages, right, we must address it. Correct? Okay. If you guys look around, is there any apparent damages? Those are not damages. These are things that cosmetic must be taken care of. Any apparent damages? See, you would all suffer from negligence or unintentional misrepresentation. Why? Because your eyes are not seeing that right above Lucia, well, close to her, there's two damaged tiles. Right? These two damaged tiles could potentially be a leak on the roof. They're not. We keep them here for presentation purposes. Always. So, what should you do? Well, Mr. Landlord, I know you want to rent this space, but it appears that you might have a leak. So here's what we're going to do. Tiles are cheap. We're going to replace the tiles. And when I call you, because I have a potential tenant, if it's raining, do not pick up the phone. What am I doing here? I'm intentionally omitting a problem. I'm telling you, if it's raining, most likely there's going to be damage. Right? So I'm telling you, let's commit fraud. That's intentional. What about if I come here and I did what you guys did? I didn't look up. Or I did look up, but it's kind of like, yeah, looks good. And I did not notice that. By the way, I'm the worst person to go list a property because I look at every detail, right? I almost got kicked out of a listing a couple of weeks ago because I'm asking, what's this? What's that? Why is this like this? Why is it like that? I just want to know because I want to protect myself, right? And you as a seller. But anyway, so negligence. You did not care enough to inspect that detail. So next day you come here with a potential tenant and the seller had already replaced it. How would you know now? You wouldn't. You were negligent the first time you did it. Does that make sense? What about, I come here, so this is the third version of this. I come here the first time to list it for sale, for rent, and those tiles were already replaced before I even got here. How would I have known? So that's innocent or honest misrepresentation. Mr. and Mrs. potential tenant, there's no apparent damages to the property. So as far as I know, there's nothing. Does that make sense so far? Mm-hmm. Okay. So that's what it is. Intentional, we're lying, and we're helping the seller lie. Negligent, we just didn't do our job. It wasn't on purpose. We just, oversight. And honest or innocent is there's no way I would have known. Okay? Now you guys can highlight this section. We already covered all this. So just highlight and mark the bullet points. At the bottom, you can highlight. Everything that you're going to highlight, I covered with a tile as examples, okay? Ready? On the right hand side on top, we already covered this as well, so just highlight. You good? Now, right here, to avoid misrepresentation. How do we avoid misrepresentation? Well, never present opinions as facts. It's not, we can certainly get you $300,000 for this house. But what it should be is, I don't see why we might not, or it should bring as much as the recent sales did. Think about it. The moment you say to somebody, Mr. Seller, I can definitely get you, or certainly get you $300,000 for the house. But then all the buying offers come at $280,000. You made yourself liable for $20,000, the difference. We never say, I can get you $300,000. We say, hey, based on recent comparables, your house should be worth $300,000. So most likely that's what it's going to bring. Open-ended. Does that make sense? We leave it open. Absolute statements should be avoided, like it's all copper plumbing. We don't know. Unless you have x-ray vision. Well, some of you wear glasses, just like I do. I have lenses. And I know when we take our glasses, we can see through the walls. Isn't that the reason why we have glasses? Right? But we can't. So how can we say it's all carpet plumbing? Impossible, right? So look what it says. Many requests for information should be met by referring the questioner directly to an expert source. The city zoning bureau, the mortgage counselor, the building inspection engineer or lawyer. And this way, the agent, you guys, shift the responsibility and cut down chances of giving faulty information in specialized areas. So, I don't know, but when I was growing up, my mom always told me, don't point fingers. Assume responsibility, right? Now I'm telling you, point fingers. Let go of responsibility as much as you can. So the home inspector told me, the seller told me, hey, the city approved it. Does that make sense? I have nothing to do with this. Give it to the mortgage guy told me. Give it to the professional. The CPA told you, not me. Are you guys understand this? So you do what you have to do in your profession. Anything that's beyond the scope of your profession, give it to somebody else. Tell them to go somewhere else. You got it? Even if sometimes you might be, let's say you also do mortgages. Try not to wear both hats at the same time. Let's say you're a contractor, you do construction. Try not to wear both hats at the same time. Huge difference. Even property brothers, there's two of them. Mm-hmm. Right? There's one that's an agent and the other one's the construction guy. Mm-hmm. Simple. And if you guys watch the shows, people ask questions, they go like, he goes like to the construction guy, hey, what about this? They do the same. They know it all. But even the property brothers, what they do is separate liability. I'm the agent, he's the construction guy. Keep it separate. Okay? Now, Consumer Fraud Act. It says that the New Jersey Consumer Fraud Act lists in detail all sorts of misleading, fraudulent, and scam practices and sets penalties that include fines of up to $10,000 for a first offense of the Act or violation of the Act. And concealing or omitting material facts about real estate is considered an unlawful practice. So if you hide stuff, it's unlawful. If it's unlawful, you could get fined and potential jail time. The Act, however, offers an exemption of liability for a real estate licensee, so you guys, if you can prove that the licensee had no actual knowledge that information provided was false or deceptive, that a diligent effort was made to learn the truth, including licensee's visual inspection of the property, or that the broker or salesperson was relying on information provided by a home inspector or similar specialist, government employee, or, please underline, the seller's property condition disclosure statement. So the seller told me, the seller wrote it down, the seller attested to these facts. I'm going by what they told me. The roof is 5 years old is because on the disclosure form, it says roof was 5 years old, to the best of the seller's knowledge. You guys got it? We don't say the roof is 5 years old. do a home inspector or the seller's disclosure statement. Very, very important. Now, antitrust laws. It says here that the real estate industry is subject to federal and state antitrust laws. The most common antitrust violations that can occur in the real estate business are price fixing and allocation of customers or markets. What is price fixing? Yesterday I told you guys that commission is 6% in the state of New Jersey, right?
No.
No? What is the commission then?
Negotiable.
Negotiable. So there's no standards, there's no fixed price, right? So any attempt by a broker to fix prices with competing offices, right, is illegal price fixing, and therefore falls under antitrust laws, okay? The other one is allocation of customers or markets. What does this mean? It means we're telling, hey, we're Remax, you guys are Riker, and I'm telling you, hey guys, let's do this. An agreement, a friendly agreement between us. We will handle properties up to $250,000, and you guys handle properties $250,000 and above. So if a buyer comes to you that wants a $150,000 house, you bring them to us. If somebody wants $300,000 house, we bring them to you. So we're controlling markets, monopolizing markets. That is illegal. Does that make sense? Mm-hmm. If you guys did not understand the word I said, understand this. Penalties for such act are severe. Under the Sherman Antitrust Act, people who fix prices or allocate markets may be found guilty of a misdemeanor punishable by a maximum of $1 million and 10 years in prison. Now you guys understood. I see your eyes. You're like, whoa. Wait, there's more. In a civil suit, a person who has suffered a loss may be able to recover triple the value of the actual damages plus attorney fees and costs. So $1 million fine, 10 years in prison, and paying them for whatever they suffer. Yes?
So, hypothetically, let's say if you
I love always hypothetical. It
if
is.
you own a franchise, example Remax, that's your company, and you decide to do whatever you want to do for your company, is that illegal?
Within the company, no.
Okay.
So if I tell you guys, agents, this month, the month of December, let's try to bring 7% listings only. It's within the office. It only becomes a problem when they know about it because one of us leaked what we're doing. See, what we're doing in office is 7%. If they found out about it, because one of you mentioned, hey, you know what we're doing over there? 7% commission. And then they try to do the same thing or less or whatever, but set standards. Now we created price fixing. That's when it becomes illegal. Okay, so within the office, it's called motivation. It's called goals. Between offices, it's called price fixing. Okay? Now, ethics, liability, or disciplinable offenses. We already covered all of this. I just want you to highlight first sentence, and then the second set of bullet points, highlight where it says civil lawsuit for damages, I just said it, criminal prosecution, I just said it, and suspension or loss of license. We mentioned that yesterday. Okay? Now look what it says. In many of the following situations, full disclosure in advance prevents liability. So if you know about it, tell me about it, right? If on the other hand, the problem is not immediately obvious, disclosure as soon as it is discovered may limit liability. So you did not know about mold in the house. 3 weeks later, you come to see the house as a realtor, and there's a smell, or you see the walls are starting to taint, whatever. Like, what is this, Mr. Seller? Oh yeah, I painted, but apparently it's not sticking, whatever. There's a little mold. The moment you found out that there is mold, right? Disclose to the buyer. Mr. Seller, I have to tell the buyer because they do not know the true value of the property. You guys got it? If there's a defect in the property, that we did not know before, but we know now, let's disclose. Right? Even if you represent the seller. Because it is a material fact, and Mr. Seller, if we don't disclose this, and later on they found out, they will sue me, but they will sue you as well. You guys got it? Yes.
What happens if he says no?
Then I'm sorry I can no longer work with you.
And you can leave at that point even though you have a signed offer.
Yeah. Well, you're going to have to disclose to the buyer.
Right, okay.
It's up to you if you want that liability to still get commission or not. Up to you.
No, I just didn't know, like, you're able to walk, kind of, I guess.
Well, you're going to talk to
away.
your broker, obviously.
Right.
Depending on the broker, yeah, let's do a paint party, I mean. All right. Disciplinable offenses. We already covered all of these as well. Racial steering, that'll be tomorrow actually. Racial steering, discrimination, violation of non-solicitation orders, and so on. We covered most of these, right? Next page. Defense against claims of liability. Defense against claims of liability. So, we make mistakes. Life happens, right? We're not perfect. I wish we were, right? But we're not. We're human. And we make errors. We might omit something without knowing, right? So, if you're driving and you make a mistake and you hit somebody, what must you have? Insurance. Guess what? We also have insurance. Ours is called errors and omissions. Because again, we make mistakes. And this is the equivalent to medical malpractice. Subject to the limitations of a particular policy, it defends against many circumstances, but does not cover fraud. So if you commit fraud, sorry, you're on your own. If it was a true, honest mistake, insurance will take care of it. Okay? We're almost done. Dual contracts. So dual contracts is we have two contracts for the same transaction, for the same house, for the same buyer, for the same seller, just different prices. One higher than the other. Why would you have two contracts for the same house, same seller, same buyer, different prices? Ridiculous, right? But people do this. Why do they do it? To get a loan commitment of a larger amount. That means we're taking home more money than what we sold the house for. So it's pretty much to defraud the bank. Yeah. In cars, that happens a lot. In mortgages, New Jersey specifically outlaws real estate sales transaction that has two contracts. Okay? Questions? No? All right, great. Ethics. Right after this one. Ethics. Can anybody tell me what is or what are ethics?
Doing the right, just thing.
The what?
Doing the right and just thing.
Doing the right and just thing. So on the right-hand side on top. Right-hand side on top. It says ethics, the third sentence there. Ethics refer to a system of moral principles. All right, this one right here. This is on the right-hand side on top. Third sentence says ethics. Okay? If you guys don't know where we are, raise your hand. Say, Bruno, tell me where we are. And I'll tell you, 112 Jabez Street, Suite 107, Newark, New Jersey, 07105. But page, right-hand, the top right corner. So ethics refers to a system of moral principles, rules, and standards of conduct, meaning knowing what's right and what's wrong and doing the right thing. That's what it is. Ethics is knowing when to do the right thing. Okay? So the ethical system of a profession establishes conduct that goes beyond merely complying with the law. These moral principles address two sides of a profession. Number one, dealing with a consumer. Number two, dealing with other professionals. See, my client is not at fault if I don't like you, right? So I'm listing the house, my client's house. And then you bring in a buyer, and I'm like, oh man, Mr. Seller, you don't want to deal with Stephanie. She's the worst. No. But her buyer could be the best. Does that make sense? If you have a personal problem with that particular person, and of course I have with you, right, Stephanie? If you have a particular problem with that particular person, that should not be expressed in the transaction. Because the seller is selling and the buyer is buying. It has nothing to do with our personal or professional issues. You guys got it? Unless you know that that person is really a scam artist, right? Then you got to be careful because they're going to scam their client, not yours. Okay? Still not your problem. Now, all the way at the bottom, professional organizations. To sum it up, what we have here is that the National Association of Realtors was founded in 1908 to help train brokers and salespeople to deal with the clients and protect the clients. Okay, there's local organizations of these this national one, so it breaks down to state and to local boards, right? And all professional activities are regulated by them. Now, what they created also is the Code of Ethics, which NAR adopted in 1913. So the association was created in 1908. 5 years later, they said, wait a minute, we have to create a code of ethics because salespeople are bad. All right? So remember, for you to be a realtor, you got to be part of the National Association of Realtors, right? Next page. That's what I was just saying. Realtor is a registered trademark. So for you to be a realtor, you must be part of the association.
They need one for car salesman.
They need a stricter one for real estate salesmen. We're right there. Like the worst type of salesman is the car salesman. Then it's us. All right? Wait, and the vacuum guy. The one that says the vacuum. You know what I'm talking about?
Mm-hmm.
Yeah. Those sales are awesome. All right. 2 paragraphs down it says, National Association of Real Estate Brokers, or in the red, whose members are called Realtists, was founded in 1947 and is particularly active in the South. Now, its membership, generally composed of African Americans, includes individual members as well as brokers who belong to state and local real estate boards affiliated with the organization. So there's the National Association of Realtors and there's the National Association of Real Estate Brokers. 2 separate entities. We don't have the red up here. It's mainly in the South. Okay? We have New Jersey Realtors. Well, it's just the state branch of NAR, as it says right here. There's national, there's state, and then local boards. Why would you participate and be a member of this union? Well, educational courses, specialized training. That's what you want. Okay? Plus resources that they provide. That's the reason why. All the way at the bottom it says, and we're done with the chapter, it says that these are private trade associations. They have nothing to do with licensing or federal or state regulations. These are private trade associations. The advantage, again, is the training and designations that you can obtain by being part of it. So if you train and you go to a course called Accredited Buyer's Representative, then who do you represent or know how to represent? Buyers. If you go to the CCIM, that means you're a commercial expert. SIOR, you are industrial. CRS, you're a residential specialist. So there's different designations based on your niche, based on your market, based on what you intend to do. You guys understand this? Mm-hmm. All right? So depending on where you're going, you want to be a property manager, there's CPM, Certified Property Manager. Depending on what you're trying to do, get those courses, get that training. Don't get them all, because you might not use it, and you every 2 years or every year, depending on the course, you might have to renew. So paying money for something you're never going to use, right? It's like going to the gym. I only went to the gym to register, but I paid for like 2 years. Did that ever happen to anybody? Mm-hmm. All right, you guys good? We're done with today's chapter. Tomorrow there's more. Thank you and have a good day.